Dear learners, we shall be starting our discussion on the topic transfer of title. In a way, this topic is interconnected to the earlier series of transfer that we have discussed in the context of property, in the context of risk. So, for transfer of title, we again have to take recourse to Chapter 3 of the Sale of Goods Act, and transfer of title is again a consequence of the contract or an effects of the contract. So, effects of the contract, as we know, they can be segregated under two heads. The first head is of transfer of property, which we have already discussed, and the other is transfer of title, that is covered from section 27 to section 30 of the Sale of Goods Act. Now we shall be looking at the various situations in which there can be a transfer of title. What is the general rule? What are the various exceptions to this general rule? So first we'll take up the rule that is contained in section 27, the general rule, which reads as, where goods are sold by a person who is not the owner thereof and who does not sell them under the authority or with the consent of the owner, buyer acquires no better title than the owner has. Now, this rule, as contained in section 27, is encapsulated in a Latin maxim, nemo dat quod non habet, literally meaning no one can give what they do not have. This is a legal rule that originated in common law and has been incorporated under section 27 of the Sale of Goods Law, which states that the purchaser of goods from someone who has no ownership right to sell them denies the purchaser any ownership title to the goods. So this is the general rule. However, what we find is that there are various exceptions to this general rule which qualify this provision, and the aim of the law to create the exceptions is to cater to certain situations where a third party who in good faith, without having proper knowledge or notice of the buyer's lack of authority to sell it, he purchases the goods. So by the principles of equity, fairness, their rights have to be protected. So this lecture on transfer of title is more about the exceptions to this general rule than the general rule itself, which is very clear and does not need much elaborate discussion. So the exceptions, they can be listed under the following heads. Firstly, the rule of estoppel, which is provided in section 27, then sale by mercantile agent, proviso to section 27, then section 28, sale by one of the joint owners, section 29, sale by a person in possession under a wordable contract, under section 30 clause 1, sale by seller in possession after sale, section 30 clause 2, sale by buyer in possession even after the sale. Then there are some provisions beyond the Sale of Goods Law, that is section 169 of the Indian Contract Act, sale by finder of the goods, and section 176 of the Indian Contract Act, sale by pawnee in certain situations. So as you can see, the general rule is like an island which is surrounded by a sea of exceptions. So to better understand the law relating to transfer of title, in what situations the title is transferred, in what situations it may not be transferred, we have to look at the exceptions. So we are going to first take up sale by mercantile agent, which is proviso to section 27. So the first requirement of this provision is that seller is a mercantile agent. Now, who is a mercantile agent is defined under section 2 subclause 9, generally meaning that he represents the seller of the goods with authority. Second is that the mercantile agent got possession of the goods with the seller or owner's consent. Third is that agent sells good in ordinary course of business. Fourth, the buyer buys the goods in good faith without notice of agent's lack of authority to sell, and he does not have the means to ascertain agent's lack of authority. Now we'll take up a case on this provision. According to the facts, an agent, that is a mercantile agent, was authorized by a car owner to sell it at a reserve price, that is a certain baseline or minimum price. Instead, the agent sold it at a price below than that and misappropriated the proceeds. So whatever was the difference, it was siphoned away by the agent. So now the question is that whether the car owner can sue the purchaser, who is a third party, to get the car back. So the question is that whether the car owner will succeed in such an action. So now let us see whether the provisions of proviso to section 27 they apply to the facts of this case. So firstly, seller is a agent as is mentioned. The second is that he got possession of the car with the consent of the owner. So the owner had given the car to the agent to sell it at a certain reserve price. The third is that it is in the ordinary course of an agent to sell the car, it is not disputed. And the buyer buys in good faith without notice of agent's lack of authority to sell. So here what we find is that the relationship between an agent and car owner, it is an inter se arrangement. So whatever the terms and conditions of their arrangement are, it cannot be known to the third party who has actually bought this car. So therefore, the third party buys the car in good faith, presuming that the agent has authority to sell the car at the price at which it is agreed upon. So in this case, although the agent did not have the authority to sell the car below the reserve price, but the title which the third party gets is a good title. And so the answer to this question would be no, and the title which the car buyer gets is a good title. Now let us move on to the second exception, that is sale by one of the joint owners as provided under section 28. Now according to this provision, if one of several joint owners of goods has the sole possession of them. So first essential is that there are several joint owners of the goods, property is jointly owned. Then one of the joint owners has got sole possession of the goods with the permission of the co-owners. Then the property in the goods is transferred to a person or a buyer who buys them in good faith without notice of seller's lack of authority to sell. So in this case, what we find is that if there is a property that is jointly owned by many people, but there is one amongst the joint owners who has the sole possession of the property. So that is a evidence enough for a third party to presume that this joint owner, he has the sole possession with the authority of other owners, and being somebody who has possession over the property, he must have been authorized by the co-owners in order to sell the property to the buyer. So if such goods are sold to a third party by one of the co-owners, even if he is not authorized to sell it by his other co-owners, This relationship between the co-owners is an internal arrangement, and the third party is not required by law to have any knowledge of them because he is entitled to presume that he has the authority. So in this case, if the goods are sold to a third party, the third party gets perfect title to the goods. So although the joint owner did not have the authority to sell, so again this is an exception to the general rule that is contained under section 27. The next is sale by person in possession under a voidable contract. So according to section 29, when the seller of goods has obtained possession of the goods under a contract which is voidable under section 19 or 19A of the Indian Contract Act, but the contract has not been rescinded at the time of sale. So voidable contracts are those which are voidable at the option of either of the parties. They are different from void contracts which are illegal from its very inception. So the buyer acquires a good title to the goods provided he buys them in good faith and without notice of seller's defect of title. So this is a rather complicated provision which contains at least two different transactions. So it is the second transaction which is protected, that is the rights of a third party. Now let us understand this with the help of an illustration. So here A owns a healthy horse. B, a veterinary expert, induces A to sell his horse to B by misrepresenting that it is in poor health, whereas it is in good health. So this is a contract which becomes voidable. That is the first sale. The B, that is the veterinary expert, then resells the horse to C, who is a third party, fetching the price of a healthy horse. So the question is C's title to the horse perfect? Now if we go back to section 29 and look at its essentials, then the first contract which is here, it has not been rescinded. So A chooses not to rescind the earlier contract. Although it is voidable, but he chooses to waive his right to rescind the contract. So in this case, even though the B got the property, even though B got the ownership of the horse through a voidable contract, but C's right would not be affected. So C's title to the horse is perfect and it is not vitiated by the fact that the seller, that is B, he got it under a voidable contract because law cannot expect C to take due diligence as to how the owner got the goods, whether he got it through a valid contract or a voidable contract. The next exception that we are going to take up is sale by seller in possession after sale, provided under section 30 clause 1. According to this provision, where a person having sold the goods, so the goods have already been sold, continues or in possession of the goods or of the documents of title to the goods, which is again an evidence of ownership, the delivery or transfer by that person or by a mercantile agent acting for him of the goods or documents of title under any sale, pledge or other disposition thereof to any person receiving the same in good faith and without notice of the previous sale shall have the same effect as if the person making the delivery or transfer were expressly authorized by the owner of the goods to make the same. So this is a rather long, complicated provision. There are a series of steps in this, but we will be able to understand it better with the help of an exercise. So the facts of this case are: A orders a pair of shoes from Flipkart on March 29th. Invoice details provide the dispatch date as 31st March and delivery on April 7th. However, a third party, that is B, orders same pair of shoes from Flipkart on March 30th and delivery is made to B on April 6th. Is B's title to the goods perfect? Now let us examine this case through the provision that we have discussed, that sale by a buyer in possession even after the sale. So here the first sale, it happened on March 29th. Delivery as well as payment of price both were postponed. However, he continued to remain in possession of the shoes till 31st March because it was the date on which the dispatch was to be made. So there was an interim period of 2 days. Now in this interim period of 2 days, this transaction has happened that a third party, that is B, orders the same pair of shoes from Flipkart on 30th March, that is in between 29th and 31st March, and delivery is made to B on April 6, one day before it was to be made to A. So the question here is B's title good? So the answer to this question is yes, because B, as a buyer in good faith, did not have knowledge of the fact that the goods that he wanted to purchase from the seller were already sold to somebody else. But because it was being shown on Flipkart's website or app that it is in possession of the seller, so therefore he was entitled to presume that nobody else has bought them. So in that case, A will have a right, a legal right against Flipkart, but B's title to the goods is perfect. Now we'll take up another case, sale by buyer in possession after the sale, provided under section 30 clause 2. According to this provision, where a person having bought or agreed to buy goods obtains with the consent of the seller possession of the goods or documents of title to the goods, the delivery or transfer by that person or by a mercantile agent acting for him of the goods or documents of title under any sale, pledge, or other disposition thereof to any person receiving the same in good faith and without notice of any lien or other right of the original seller in respect of the goods shall have effect as if such lien or right did not exist. So now again, this is a rather long and complicated provision. We will try to understand it with the help of an exercise. So supposing A sells a shipment of cotton to B and forwards blank price bill and document of title to B for securing the payment. So here there has been no payment being made. But the buyer has got document of title to the goods. Now a third party, that is C, separately contracts with B to provide him shipment of cotton. Now B, instead of making payment to A, transfer the price bill and blank document of title to C for payment. C makes the payment to B. Now here the question is that when B had not paid the price to A, so he was in breach of a contract. So there is a question mark on his title to the goods. But because he had document of title to the goods, so C, the third party, was entitled to presume that B is the legal owner of the goods. And so if C has made the payment of the goods to B, then C acquires a good title. Even though B's title to the goods is defective. But this provision is to protect the interests of the third party who buys the good in good faith on the presumption that he who has possession of the goods as well as document of title to the goods, he is the legal owner, and therefore a transaction of sale can be made. Now, based upon this, there is another case. The name of the case is Belsize Motor Supply Company versus Cox. The facts are A enters into a hire purchase agreement with B for B's car. We know what is a hire purchase agreement. We have earlier discussed it, distinguishing it with a contract of sale. Before all installments were paid, A sold the car to C, the third party, who in good faith and without notice of B's right over the car bought it. So is C's title to the car good? So we know what is a hire purchase agreement and how it is distinguished from a sale or an agreement to sell. So hire purchase agreement is not in the nature of a sale or an agreement to sell, because it is something that is conditional upon the payment of the last installment. If any default is there, then the property reverts back to its true owner. So here the hirer has the option at the end of the last installment. He can propose to buy the goods or he can choose not to buy the goods, in which case it goes back to its true owner. So because this probability is there in a hire purchase agreement, that is an option to not buy the goods, in that case the hirer has a defective title over the goods, and so he cannot transfer the property with a defective title to a third party in case of a hire purchase agreement. So in this case, C's title to the car good? The answer is no, and the reason for this is because A had not agreed to buy the goods. Now we shall move to the next exception, sale by finder of the goods under section 169 of the Indian Contract Act. According to this provision, when finder of thing commonly on sale may sell it. So it provides certain situations on which it can be done. When a thing which is commonly the subject of sale is lost, and if the owner cannot with reasonable diligence be found, or if he refuses upon demand to pay the lawful charges of the finder may sell it, firstly, when the thing is in danger of perishing or of losing the greater part of its value. So this relates to what we call as perishable goods. So any consumption item, for example, which is time barred. And secondly, when the lawful charges of the finder in respect of the thing found amount to 2/3 of its value. So in this case, the finder of the goods is not the true owner. The owner is somebody else who has lost the goods. But if some conditions of this provision are met, then the person who buys the good from the finder of the goods, he gets a good title. But for that, some requirements have to be fulfilled. Firstly, the finder of the goods has to undertake reasonable diligence of finding the true owner. If he does not take this due diligence, then the buyer does not get good title. The second is that he has done the due diligence, found the owner, but the owner refuses to pay the lawful charges to the finder of the goods. So now the finder of the goods gets a lien over the goods. In that case, he may sell it if it is a perishable goods, or when the charges of the finder, they amount to 2/3 of its value. So in this case, whosoever buys the goods gets perfect title to the goods. The next is sale by a pawnee under section 176 of the Indian Contract Act. Again, this is a provision that lies outside the scope of the Sale of Goods Act. According to this provision, pawnee is right where pawner makes default. If the pawner makes default in payment of the debt or performance as the stipulated time of promise, in respect of which the goods were pledged, the pawnee may bring a suit against the pawner upon the debt or promise and retain the goods pledged as collateral security. Or he may sell the thing pledged on giving the pawner reasonable notice of the sale. So the essential thing here is that pawnee gets certain lien over the goods, and that lien is a right against the pawner. So if the pawner makes a default in satisfying the right of the pawnee, then there are a bundle of rights or options that are available to the pawnee. So he may bring a suit, for example. He may retain the goods as a collateral security, and he may also sell the thing. But he has to first inform the pawner of his intention to sell. So in that case, the right which the buyer of the goods gets under section 176, that is a good title. So with this, we come towards the closure of the discussion on transfer of title. We've discussed the general rule of section 27 that no one can give what they do not have, or there cannot be a sale of goods by a person who is not the true owner. Generally, it is reserved for those whose ownership rights over the goods is perfect. But there are certain exceptions that the law has created in order to protect certain third-party rights who buy the goods in good faith without having knowledge or notice of the seller's defect of authority to sell. It can be by way of an estoppel under the law of contract, section 27 of the Sale of Goods Act, sale by mercantile agent, proviso to section 27, sale by one of the joint owners under section 28, sale by a person in possession under a voidable contract, section 29, sale by seller in possession after sale, section 30, clause 1, sale by buyer in possession after sale, section 30, clause 2. So these provisions that we have, they are with regard to the Sale of Goods Act, and the last two provisions with regard to the Indian Contract Act. So because transfer of title by sale of goods is also a kind of contract, it's a special contract. So there are certain situations in which some general rules of the contract also apply to a contract of sale of goods and shapes the rule relating to transfer of title. So under the Contract Act, we have sale by finder of the goods and sale by a pawnee. With this, we end our discussion on transfer of title. Thank you very much.